welcome to another episode of Ask Me Anything with Sky Unlimited Legal Advisory. My name is Yaasha Sabba, and I'm going to answer one question today because it takes too long answering so many questions. All right. I'm currently taking care of my grandmother, 95 years old, and her brother, so your uncle, 91 years old. What are the things I need to do to be their legal guardian? To be able to deal with their insurance, bills, bank. I've been asked many times to have any documents that deemed me responsible or the legally responsible person. I'm not sure what the responsibilities or the legal process of being guardian. Okay, so your grandmother's 95 years old, your great uncle is 91 years old. The one thing you didn't tell me is, do they have capacity or not? So becoming a legal guardian is not an easy process. It's pretty straightforward, but what you're essentially doing is you're going to court and you're telling a judge that, hey, this person, this individual is not capable of taking care of themselves or taking care of their finances. Another word of this court process is called conservatorship. You're either becoming their guardian or their conservator. That just basically means you are in charge of their money and their person or their body. So you get to dictate where they live next. You get to dictate what nursing home they go into. You get to dictate how their money is spent, how their money is used. You have full control over their lives as if they are your own child. That's how powerful it is to become someone's legal guardian. And to that someone, that's a very dangerous position for them to be in. A very big example of this that's hitting the headlines today is Britney Spears. Britney Spears right now, for the last 10 years, has been fighting her father because he, in California, obtained a legal conservatorship over her after she had a very big meltdown where she shaved her head. Now, she might have been going through a lot of just deep personal psychological issues at that time. And there might have been a reason where someone steps up saying, hey, here's a multi-million-dollar empire that was built, and this person who's in charge of it is really not capable of handling it themselves. So her father went to a judge and said, Judge, look, she doesn't have the capacity to take care of herself or her children or her business, and you should put me legally in charge. So the judge did a mental review of her, analyzed her, and said, yes, Father, I believe you're correct. I believe she doesn't have the capacity, and I think you are the right person to be in charge. That happened, and now, 10 years later, Britney Spears is totally fine, seemingly. She doesn't have mental health issues. Seemingly, she's still giving concerts. She's still giving tours. She still has her 2 children who are growing up. She has relationships. She's tweeting. She's on TikTok. She's on Instagram. So it doesn't seem like there's any issues with her. Yet, under the law, she's still not in control of her life. Her whole entire family's in control of her life. In fact, her father is still legally her conservator. Now, I think they just recently, in the last few months, they did an adjustment of the court where they changed the conservator. So there might be someone else that's in control, not necessarily her father. That's what she's trying to fight. But she's still under this conservatorship. There is still someone that's her guardian, so to speak. So it really is not fun at all when you have capacity and you really don't need that extra layer of help. It is very hard to get out of a guardianship or a conservatorship once you're in it. And so your grandmother or great uncle, they might have capacity. They might need a little bit of help with someone taking them to the bank or the grocery store, someone helping them just write their checks and their finances, but they might not want someone else being in full control over their lives or person. They might still believe that they're independent. And if you go to court and put them under a guardianship, it's the same as pulling a rug out from under their feet, especially if they're not incapacitated. Does that make sense? So I'm going to give you an alternative option. An alternative option is not necessarily to go to court and take this drastic legal regime and become capable of handling things. It sounds like you're not really trying to take over their lives or dictate how things go. It sounds like you're just trying to help them take care of their affairs, pay their bills, the insurance, and all that kind of stuff. So another option is having them create a power of attorney. You don't need to go to court. You don't need a judge. It's not a public process. This is all done privately. If your grandmother and great uncle still have their mental capacity, meaning they're not diagnosed with dementia and going in and out of fluidity, they can still talk to you, they still read books, then why not just have them sign a simple document that you can have an attorney create for you, or you can get off of LegalZoom. The versions on LegalZoom are good, but they don't cover everything. So we should still have a conversation on what you may want to make sure that is in that power of attorney in order to not have any hurdles down the road. Happy to chat about that. But with the power of attorney, you can do all those things. You become their agent, not their guardian or conservator. And as their agent, you can act in whatever that power of attorney authorizes you to do, to act. So California has a simple form where you just have them sign it and sign which powers they want to give you, and they can give you all the powers. And when they do that, you then have the ability to go to the bank to act on their behalf as if you were their conservator or guardian. The difference here is instead of you putting them into a conservatorship, they are giving you this power themselves, and they can always take it away as long as they have capacity. Now, you can create a durable power of attorney, which means if they lose capacity on their power of attorney document, they said, even if I become incapacitated, my grandson is still my agent under this power of attorney. We call that durable, right? So you can create something like that and still have the power. And the moment that they pass away, that's when that power becomes void. But it's much easier, much cheaper to do that. And that's what I highly recommend you do. This is why in the estate planning world, we tell everyone, don't fall into the trap where if you can't take care of yourself and you need someone else taking care of you, even if it's temporarily, make sure you have a power of attorney already created so that it can kick into gear at the moment you become incapacitated. You can limit power of attorneys, saying, I choose this agent to take care of me, but their authority is not effective until I become incapacitated. We call that a springing durable power of attorney, right? But if you don't have that power of attorney document, or if, let's say, your grandma and great uncle, heaven forbid, let's say they don't have capacity. Let's say they have dementia or Alzheimer's. Well, if they don't have any estate planning documents done in advance, if they didn't plan for the fact that they might one day get into that state of incapacity, then you have no choice. You have to go to court. You're going to start by not hiring an estate planning attorney. You're going to hire a family law attorney, because this is in the family law court because they haven't passed away. And you're going to ask the judge to appoint you as the guardian. Now, there's no guarantees the judge is going to appoint you. That's the thing. A judge is a total stranger. The judge doesn't know you. Their job is to make sure that you are a responsible person. There's no law that says family members have to become the guardians, or that relatives or best friends or the attorney even. If the judge doesn't trust you, if the judge doesn't think you're a responsible person, the judge is going to appoint an attorney. And who pays that attorney? Well, your grandmother and great uncle through their assets. And the attorney gets paid by the hour. The attorney will report that to the court. More court hearings, more court filings, more costs. You think about that. So be very aware that you need to make sure you are a responsible person and you can convey that and show that to the judge. And when you hire the attorney to have the guardianship hearing proceedings, it's probably going to take about 4 to 6 months before you can become guardian. Court is very slow. You are on the judge's timetable, the court's timetable, not your own. So if there's any emergencies or anything like that, the bills need to be paid. If they've got a mortgage, somebody needs to pay that mortgage. Even if it's out of your own pocket, you can always get reimbursed from them, right? With the guardian can reimburse you, or if you're the agent, you can reimburse yourself. But if that mortgage isn't getting paid, the bank has a right to foreclose regardless of what's going on in your life. And the courts are very clear about that. We can't mess with that. So make sure that mortgage is getting paid. Other bills, you can kind of let them sit for a while until you finally have the authority to go into the bank accounts and pay them. I don't recommend you go into your bank account and pay their bills unless it's an essential service or item that your grandmother or great uncle's receiving, just so that they don't lose those essential services. But don't pay those bills yourself out of your own money unless they are essential services, because you're not entitled necessarily to get that back. There's no process on getting that back until maybe they pass away. So that will totally suck on your end. So If you want to follow up with me and let me know what's their capacity, it sounds like they might just be of old age and need a little bit of help, that they're not incapacitated. You want a power of attorney. Don't go for guardianship or conservatorship. But if they're already incapacitated, then I'm very sorry to hear that you have to go to court to be appointed as the conservator guardian, and you're going to need a family law attorney to assist you with that. All right, everybody, that's it for today. I will talk to you next time. I hope everyone's doing well. Stay safe. Get your estate plans done. Take care.